Welcome to this webinar and Live With or Shared Care Orders and More, a guide for private children lawyers. This webinar will provide you with a clear understanding of when a Live With or Shared Care Order may be appropriate in private law proceedings. What will you learn in this webinar? You will get a brief coverage of Shared Lives With Order as it relates to the Children Act 1989. There will be a summary of the decision of AZ and BX Child Arrangements Order Appeal 2024. We will ask the question, has the case of AZ and BX changed or developed the approach to making final child arrangements order? We'll also be advancing a case for or against a shared lives with order. The key question which will be answered then is, how has AZ and BX 2024 changed existing thinking on shared lives compared to live with and spend time with orders? And how should you argue for or against spending time with orders and shared lives with order? Before I look at those specific questions, I think it would be helpful to recap one or two concepts and definitions. The focus, of course, about the orders made by courts in private law proceedings about children between their separated parents. In relation to the evolution of these orders and going back to some distant past, in the days well before the 1989 Children Act, courts, of course, made custody of and access to orders. And if you think about the use of those words, they're very possessive and they're also deemed to be very adult focused. So we would see parent A being granted or awarded the custody of a child, and parent B is awarded the right of access to that child. Now, as is known, that changed with the 1989 Children Act, which was very deliberately a child-focused fine-tuning of the previous law. What was created instead of custody and access was two separate and distinct orders, a resident order and a contact order.